Do you think that the Congress can disarm people who are mentally ill, who have been committed to mental institutions?
So setting aside an enumerated powers problem, so they're in the District of Columbia or something like that, there's definitely a tradition for restricting sale or provision of weapons to the mentally ill. That all the examples that the government has cited are late. They're post-Civil War sources, I think, for that. If not, so I think maybe is the answer to this
I'll
tradition.
tell you the honest truth, Mr. Wright. I feel like you're running away from your argument. Because the implications of your argument are just so untenable that you have to say, no, that's not really my argument. I mean, it just seems to me that your argument applies to a wide variety of disarming actions, bans, what have you, that we take for granted now because it's so obvious that people who have guns pose a great danger to others, and you don't give guns to people who have the kind of history of domestic violence that your client has, or to the mentally ill, or what have you. So I guess I'm asking you to clarify your argument because you seem to be running away from it because you can't stand what the consequences of it are.
Your Honor, I am running away from interest balancing because I understand that that same sort of argument could have been made in Bruin, could have been made in Heller, could have been made in McDonald, and in fact were made in all of those cases, right? Legislatures have made a judgment that it is dangerous to have people carrying weapons about. Legislatures made a judgment it's dangerous for handguns specifically to be possessed. And the court didn't defer to those late or mid-20th century judgments, or even early 20th century judgments about dangerousness in that scenario. Instead, the court said, we are going to follow our understanding of the original public meaning of the text and as illuminated by the historical tradition of firearms regulation at the margins. So I guess that's what I want to say is that if there's no such tradition, so if you couldn't, I'm supposing that we would find examples of people having firearms removed from them if they are in imminent danger to others. That historical record has not been built in this case because that's not the kind of law that we have. I do believe that it's there, and I could give some additional examples where I think we could find support for that. But if not, if there were no historical support for that, we would be left with what the text says, which is you have a right to keep arms. And so in that sense, that would end.